Chapter 5. The System at Work. During recent years, a practice has grown up and is rapidly being extended whereby Parliament delegates to the public departments more or less wide powers of legislation. In consequence of the increasing demand of the departments for legislation giving them the detailed control of matters connected with the local government, health, education, industry, housing and so forth, Parliament is, it is said, overburdened and quite incapable of dealing adequately and in detail with the subject upon which it is invited to legislate. The words in consequence of the increasing demand of the departments for legislation may be used advisedly, because the public may probably think that there is too much legislation, and also that there are too many public officials. It is interesting to note that the growth of the system of subordinate legislation by the departments has proceeded side by side with a great increase in the number of public officials. There are various forms of departmental legislation. Sometimes Parliament passes an act expressing its intention in general terms and leaving the mode of carrying out that intention to be settled by rules and regulations to be made by the public department which is charged with the supervision of the matters legislated upon. Sometimes the department is given power to make orders having the force of law with reference to the subject matter of the statute, and in some cases the department is empowered within limits to repeal or vary the express provisions of the act conferring the powers. For instance, by Section 1, Subsection 2 of the Road Transport Lighting Act 1927, the Minister of Transport may exempt, wholly or partially, vehicles of particular kinds from the requirements of the Act, and by Subsection 3 he may, by regulations, add to or vary such requirements. Again, by Section 1 of the Trade Boards Act 1918, the Minister of Labour may, by special order, extend the provisions of the Trade Boards Act 1909 to new trades, or withdraw any trade from the operation of that Act, and may alter or amend the schedule to the Act. By Section 2, Subsection 1 of the Act of 1918, a special order so made is to have effect as if enacted in that Act. There are recent instances of the power of modifying the provisions of the Enabling Act which has been given for the purpose of removing difficulties in bringing the Act into operation, two of which are as follows. The Unemployment Insurance Act 1920 by Section 45 provides, if any difficulty arises with respect to the constitution of special or supplementary schemes or otherwise in any other manner whatsoever in bringing this Act into operation, the Minister of Labour, with the consent of the Treasury, may by order do anything which appears to him necessary or expedient for the constitution of such schemes or otherwise for bringing this Act into operation, and any such order may modify the provisions of this Act so far as may appear necessary or expedient for carrying the order into effect. By the Rating and Valuation Act 1925, Section 67, Subsection 1, to which reference has already been made, if any difficulty arises in connection with the application of this Act to any exceptional area or the preparation of the first valuation list for any area, or otherwise in bringing into operation any of the provisions of this Act, the Minister of Health may by order remove the difficulty, or constitute any assessment committee, or declare any assessment committee to be duly constituted, or do any other thing which appears to him necessary or expedient for securing the preparation of the list, or for bringing the said provisions into operation, and any such order may modify the provisions of this Act so far as may appear to the Minister necessary or expedient for carrying the order into effect. The extent to which the courts of law have jurisdiction to review and question the validity of statutory rules and orders depends, of course, upon the terms of the statute which gives the power to make them, and from which their force is derived. Sometimes such rules and orders are, as they manifestly ought to be, liable to be challenged on the ground that they are not within the powers of the authority making them, or in other words, that they are ultra vires, or on the ground that in making them, the authority did not exercise the discretion vested in it, but took into consideration extraneous matters. The usual means whereby the courts secure that the departments shall not legislate in abuse of their powers is by the prerogative writs of prohibition or certiorari, which are issued by the King's Bench Division of the High Court. By the writ of prohibition, a department which is proceeding with the consideration of a statutory rule or order in excess of its powers may, before the rule or order is made, be prohibited by the court from proceeding further in the matter. And by the writ of certiorari, the department may be commanded to bring into court a rule or order after it is made, so that it may be reviewed and, if it is found to be ultra vires, or if it is found that the department took extraneous matter into consideration, may be quashed. Sometimes the enabling statute provides that the rule or order shall be laid before Parliament for a certain number of days, and, if it is objected to during that time by resolution of either House, shall be annulled. But such a provision does not prevent the court from inquiring into the validity of the rule or order, and, if it is found to be invalid on either of the grounds above mentioned, from quashing it, either before or after the expiration of the period during which it is before Parliament. But, provided that a rule or order is not invalid on the ground that it is ultra vires, or on the ground of extraneous matter having been taken into consideration, the court has no jurisdiction to review it on its merits, or to inquire into the soundness of the discretion exercised by the legislating department. The court can prevent a department from acting illegally, but cannot require it to act reasonably. Where delegated legislation is subject to judicial control, it is perhaps not open to the most serious kind of objection, but various forms of words have been used in connection with this sort of legislation in order to limit the controlling power of the courts, and in some instances, where private rights are seriously interfered with, the jurisdiction of the courts has been entirely ousted, and the officials in the exercise of their powers have been rendered wholly free from judicial control. Sometimes it is provided that the minister, an expression which of course means some official in his department, may make such orders as he shall think fit, apparently with the view of indicating that he is intended to have a very wide discretion, and of preventing the court from interfering with any order, whatever its terms, relating to the matter concerning which he is given power to legislate. So, for example, Section 10 of the Roads Act 1920 provides that where any persons are, whether by virtue of any act or otherwise, liable to pay any sums, by way of mileage charges or other annual payments, in respect of the use of any road by their vehicles, the Minister of Transport may, on an application by those persons in that behalf, and after considering any objections made by any person interested, suspend, modify, or determine the liability to make the payments, as he shall think fit. So again, by Section 6, subsection 5 of the London Traffic Act 1924, the Minister of Transport may, on an appeal, make such order amending the schedules of omnibus routes and services as he may think fit. Another form of words that has been used is that a decision on the minister on a question shall be final and conclusive, as in the case of the following sections of the Town Planning Act 1925. Section 1, subsection 3, the expression land likely to be used for building purposes shall include any land likely to be used as, or for the purpose of providing, open spaces, roads, streets, parks, pleasure or recreation grounds, or for the purpose of executing any work upon or under the land incidental to a town planning scheme, whether in the nature of a building work or not, and the decision of the Minister of Health, whether land is likely to be used for building purposes or not, shall be final and conclusive. Section 7, subsection 3. If any question arises whether any building or work contravenes a town planning scheme, or whether any provision of a town planning scheme is not complied with in the erection or carrying out of any such building or work, that question shall be referred to the Minister of Health, and shall, unless the parties otherwise agree, be determined by the Minister as arbitrator, and the decision of the Minister shall be final and conclusive. There are other cases where it is expressly enacted that an order made by the Minister shall not be subject to an appeal to any court. For instance, Section 9 of the Roads Act 1920 provides for the issuing by a county council to any manufacturer of or dealer in vehicles of a general licence in respect of all vehicles used by him at a reduced duty in lieu of separate licences in respect of each vehicle, and subsection 3 is as follows. If any person is aggrieved by the refusal of a council to issue a general licence under this section, he may appeal to the Minister of Transport, and the Minister shall, on any such appeal, make such order in the matter as he thinks just, and the council shall comply with any order so made. An order made by the Minister under this provision shall be final and not subject to appeal to any court, and shall, on the application of the Minister, be enforceable by writ of mandamus. A similar provision is contained in Section 4, subsection 3 of the same Act as follows. Where, upon application for a licence to ply for hire with an omnibus, the licensing authority either refuses to grant a licence or grants a licence subject to conditions, in either case the applicant shall have a right of appeal to the Minister of Transport from the decision of the licensing authority, and the Minister shall have power to make such order thereon as he thinks fit, and such order shall be binding on the licensing authority. An order made by the Minister under this subsection shall be final and not subject to appeal to any court, and shall, on the application of the Minister, be enforceable by writ of mandamus. The writ of mandamus here referred to is the prerogative writ issued by the King's Bench Division of the High Court, whereby the court compels the performance of a duty of a public or quasi-public nature. Subsection 2 of Section 4 of the London Traffic Act 1924 provides, with reference to schemes for the closing of streets for works of road maintenance and improvement, that on the confirmation of any such scheme by the Minister of Transport, it shall become final and binding on all road authorities affected, and shall not be subject to appeal to any court. Another provision, which is frequently inserted, presumably because it is intended to deprive the court of jurisdiction to inquire into the validity of a rule or order after it is once made, is that the rule or order shall take effect as if enacted in this Act. This provision is apparently thought to give the rule or order the status of an Act of Parliament, the validity of which cannot, in any circumstances, be questioned. So, for example, the Poor Law Act 1927, which vests in the Minister of Health the direction and control of all matters relating to the administration of relief to the poor, provides, by Section 211, 1. For executing the powers given to him by this Act, the Minister shall make such rules and orders and regulations as he may think fit for a. The management of the poor, b. The government of workhouses and the education of children therein, c. The apprenticing of children of poor persons, d. The guidance and control of boards of guardians and their officers as far as relates to the management or relief of the poor and subject to the provisions of this Act prescribing their duties, e. The making and entering into contracts in all matters relating to such management or relief, or to any expenditure for the relief of the poor, f. The keeping, examining, auditing and allowing of accounts, and g. Any purposes for which rules, orders or regulations may be made under this Act and generally for the carrying of this Act into execution in all other respects. 2. All rules, orders and regulations made by the Minister under this Act shall have effect as if enacted in this Act, subject, however, to the power of the Minister to suspend, alter or rescind any such rule, order or regulation.